have the
Meeting is being recorded.
pledge allegiance to the flag
of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Records show that Marilyn Clark and Lisa Thayer are participating virtually. And you must remain visible throughout the meeting. Well, this is going to be a very easy meeting because we have nobody here for applicants. So the first order of business is the Tobby Farm lot line modification. I've been asked by the applicants if I would try and see if the town board can be persuaded to approve this purchase. I did, and I think it is going to be approved. Probably before the end of the month.
Don, just so that you know, this is not happening on the participants end.
Oh, excuse me.
For some reason, it's happening on my end, and I don't
What?
know why.
Did the board,
The televisions keep going. I keep losing the participants. So my apologies. Not quite sure why.
Whoever is still out there, can you bear with us? We are getting.
I'll start there and then I go back into here. Okay, I got it.
Okay. At any rate, we will adjourn the slot line application until next month, which is what, February?
February, I think it's the 9th. Yes, February 9th.
Till February 9th. Can I get a motion?
so moved.
Get a second? Okay, all in favor?
Aye.
Aye.
Okay. Site plan review is application, which you will recall from our last month meeting, is being revised, and it's going to be substantially revised. And the applicant has requested an adjournment to February 9th for them to have a new presentation for us. So can I get a motion to adjourn that to February 9th?
So moved.
Second.
All in favor?
Aye.
Aye.
Okay, Meadowmere. You're still having problems with the health department and drilling wells, so he has requested another 90-day extension of his subdivision plan. Can I make a motion to extend that for an additional 90 days? I have the text of the motion somewhere, but I can't find it.
So moved.
Oh, wait, it's one paragraph.
You can deem it read into the record, Don, and I will
Here it
put
is.
it in the minutes.
It's just adjourned for 90 days. And the time for submission for a final plat is extended an additional 90 days. So somebody
So moved.
gonna get a second. All in favor?
Aye. Aye.
Is there anybody here on the Wolfer Trust subdivision?
Okay.
Anybody?
What's happening?
All right, I'm in. Thank you.
Stephen Kiley just joined. Stephen, can you turn your microphone muted, please? do to get it back in?
Do you know why this is
I
happening?
don't, it didn't happen, so, I don't answer to that. But, I'm glad it worked out.
Is Eric Bregman disappearing?
No, I see 6
Sorry,
people.
down on.
Eric, can,
Yeah, all right.
do you want everybody to have their video on, Don?
I don't care, just board members.
Okay, then the board members are on. Just to give you an update, that the other people in the meeting, in the Zoom meeting room are Eric Bregman, Anton Borovina, and Stephen Kiley. Stephen Kiley just joined, and he is joining for the neighbor to the chicken application you're gonna look at today. Chicken, keeping of chickens.
Okay.
But no, I do not have anybody that is representing the local.
On the Wolver Trust subdivision. This has been going on now for much too long, and part of it seems to be the inability of the client's counsel to perfect an application that we can grant. And so I am going to propose that we give them another 90-day extension. I want the village clerk in writing to communicate to the applicant's attorney that what has been submitted is woefully incomplete, and that this is the last 90-day extension that we will be granting. And he must, if he wants us to do anything on this, other than to let the subdivision, prior subdivision approval lapse and go back to square one, is he must submit 30 days before the termination of this 90-day extension, a complete package with requisite signatures, tax identification numbers, schedules that are referred to in the document, and with some wording changes that will be sent to him that are going to be required. And
Yes.
so let me see a copy of that letter and send a copy also to
Okay,
Ryan.
you need a motion on that extension.
So can I get a motion for that?
So moved.
extension?
Second,
All in favor?
Aye.
aye.
Is there anybody to hear speak on this application of Nairi McClay? The lot line subdivision. I don't know what you do.
I do know that they came
Yeah,
in.
it's some kind of fakakta thing. I want to say attending. I'm trying to attend.
Anton, could you put your microphone on mute, please?
That generally speaking, you would think that I should know that in fairness, technology changes. My understanding is if you're running the meeting, I'm in the meeting. Yes, hello.
Can you please mute yourself?
Hello?
Can you please mute yourself?
Oh, I'm sorry. Yes. How do-
Thank you.
Let me do that. Hold on. Let me do that.
Thank you. I know that Joe Lombardi joined the first Zoom because I can tell by my emails. I sent him the second link and I sent him an email telling him to come in the meeting on the second link, but he's not here. So I can have my
I'm willing
office
to
call.
postpone discussion,
Okay,
but if there's nobody here to speak to the application,
there is not done.
what do? We can't adjourn because we haven't opened it.
Right, correct. So I would carry it on, if you want, you can carry it on the calendar, set for the next if you wanted to. So there's no one to speak on a presentation for it.
So let's wait till the.
Maybe he'll come in.
Right, and I can,
we do it.
I'll tell I'll tell Abby to call the office.
All right, because there's a number of problems with this that have to be
Yes, that has
discussed.
to be addressed.
We might luck out. We'll, because my screen is coming in and out. Maybe initially they'll be able to get through.
Okay, moving on then to the height fence application. Okay, let's start together. The hearing on this application is still open. Is there anybody who wishes to speak to the application? The application, which was the same as what was discussed at the last meeting, shows the construction of an 8-foot deer fence around the entire perimeter of the farmland parcel.
Hello? Hello, Mr. Chairman?
Yes.
Can I be heard? This is Anton Borovina. Can I be heard?
Yes. Yes. Speak, please.
Okay, for some reason, I don't know if you, I cannot, I see you, but apparently I don't think you can see me.
At the moment, we can't.
You can or cannot? Now you can.
Now we can.
We're
There
having.
you are.
Well, we can hear you.
Good, by the way, obviously these masks and the acoustics is, I'm hearing only bits and pieces of now Jim Pike's
We can
application.
hear you clearly.
Oh, okay. I think it's the other end. I'm not hearing you as clearly. Am I correct that before you now is the application of James Pike?
You're correct.
Okay. Well, I don't know if it's my opportunity to speak now. I can tell you that the neighbors on the south and Jim Pike were involved in negotiations commencing on Labor Day. Jim Pike acknowledged and agreed that he would have his fence located 10 feet inward on the south side of the property. And on that basis, it was understood that he would be given an easement over the common driveway on the south side. That was our understanding. He, by the way, I must tell you, he told that to me several times, including at the last meeting, reaffirmed his commitment to do that. I was on Monday, I was told that there was going to be a planning board meeting on Monday. And my client, and to carry that forward, it turns out that I got an email from Jim Pike's counsel Monday afternoon, apologizing and saying apparently there's a confusion of some kind. The meeting has been adjourned till Wednesday. And okay, and I actually sent a letter to Tony Tohill, regarding this and saying that Jim Pike wanted it adjourned till February for various reasons. And I said, fine, it will give us the opportunity to finalize, no ifs, ands, or buts, finalize the agreement that had been worked out on Labor Day this past year. I now find out that the application is not, I got an email yesterday, not only is the application going forward, but apparently it's so forward that not even the attorney or Jim Pike is going to be present regarding all of this. And I want to and I had indicated to my client's prejudice that there is nothing to do as of Wednesday because the matter was going to be adjourned. And we do have objections regarding the location and the fence on the relative to his property, more particularly on the south side. He had indicated
those objections.
I'm sorry?
You state those objections.
I can't hear you.
Yes.
What? I'm sorry, I didn't hear what you said, Mr. Chairman.
What are your objections that you
My
just-
objections are that he did not properly comply with the criteria for the granting of the application. There are alternatives. I was in contact with the cooperative center both in Maryland and in Rochester. There are alternatives to an 8-foot fence available to ward off deer predation. He had indicated in an offhanded way that he has tried to use his existing deer fence, which was consisted of a single electric line that apparently is not as effective as he hoped it to be. Whereas there were other technologies that were available. There are other criteria as well. By the way, I outlined them in my initial letter to the board many months ago. Now, again, all that I must say that essentially, as of Labor Day, no longer was the focus of any further involvement or discussion, except to the extent to work out an agreement with all neighbors on the south, particularly on the with respect to those who have control of the common driveway on the south, that would have done this. And Jim Pike, by the way, he said this, I got to tell you, he said it to me indirectly. That was his intention. He said it to me on the phone a week and a half ago. That was his intention. He had not abandoned it. That was his intention. I said, fine. By the way, may I say, without this, I have been trying in the past to reach out to his lawyer. I have recently.
Anton,
Yes.
it's Brian Egan. How are you?
Hi.
Can I just interrupt for a second? So the matters of private negotiation or attempts at resolution are really not pertinent to the consideration of the granting of an agricultural offense under the village code. We encourage that. We think that that's a fine thing to do. It's neighborly, but it's not one of the pertinent considerations under 245 49D for the granting of an agricultural fence application. The mayor's question was, do you have any today specific objections that would require or in your opinion militate for the denial of the fence application?
I most certainly do, and I outlined them in my initial letter. I can go for. I would have been prepared, frankly, to go forward with them if I understood that the matter was going to be presented to the board today. I was told it was going to be adjourned, and adjourned not to go into the merits, not on the merits, but with respect to an understanding that was reached with the neighbors to the south. I am now effectively ambushed. I'm disappointed to hear this, that Jim Pike has, there's an ambushing going on, as I see it, where I am told at the 12th hour that we're going forward on the merits. By the way, we're going forward to such an extent that neither Jim Pike nor his attorney are going to be present. So then they're not even in the room to prosecute. They're not even in the room, by the way, to dispute what I just said to you, to tell you that Jim Pike affirmed remove the fence. On that basis, we relaxed we withheld further forensic examination of the application. If you're asking me what was done to date, I have reached out to the co-op in Maryland and to Rochester, and I've spoken to two different people. Vincent, by the way, Vincent Apicello, I believe, who has written a book on this stuff in Maryland. So, there are alternatives to consider. He didn't, and they've not been addressed by the applicant. There are other things were not also addressed. He may have said some of them extemporaneously, but however, he did not formally address it. So the application in that respect is not complete. And we do have information, and we would like to give to the board that would show that there is no suitable alternative. I'm sorry. There is a suitable alternative rather than an 8-foot fence. I
believe this.
Had I been told this, this is unfair. Had I been told this up front by Jim Pike and the attorney, it's not clear to me that the attorney's at fault. But I actually think Jim Pike just decided unilaterally to change his mind and then woke up one day to say something about it, which is disappointing to me. I didn't think that was going to happen, but apparently it did. So now, and after, look, I'm not repeating myself. You understand my position. I'd like to have the matter adjourned to February.
We have in our possession your letter that you submitted to the board.
I'm sorry. I can't hear you. I'm sorry. You're coming in muffled. I think the masks are muffling things.
Can you understand now? Can you hear me now?
I hear you, but I can't hear all your words because they're muffled.
Can you hear me better now?
Yes.
We are in receipt of your letter asking for an adjournment. believe that all of the objections that you have and that you have voiced at the outset of this hearing are in the record. We also have in the record your statement from last month's meeting that, and when we explained that there was simply an application now for James Pike to put a fence on the perimeter of his property, all on his property. And you said, if he does that, fine, we have no objection. That's your words. And that's so it's exactly
It was
what we
with-
are intending to do here now, is to grant that application, which was before us last month, to give him a fence on the perimeter of his property, fully utilizing that property, and with access gates at the 2 points of the parcel where he does have a 10-foot right-of-way. And if you still want to negotiate with Mr. Pike for an alternative, obviously you're welcome to do it. I think, though, as far as the board is concerned, Mr. Pike has met all of the requirements in the code according to our assessment. And in your letter, by the way, you explained that you only represent 4 of the property owners on the south side. And that even if you do make an agreement with Mr. Pike, it's not certain that he will have access because it will be dependent on the owners of the other 2 rights of way. So it's not as if your negotiations with Mr. Pike would be determinant in what he can do. But you will be, there's nothing to prevent you or him, and he is aware of it, and which he noted to us on Monday when he was in here and said, please go ahead and act on the application.
By the way, apparently he said this, notwithstanding a later communication by the attorney that the application was going to be adjourned till February.
But
And to the extent that objections, Mr. Chairman, to the extent that there were objections that I had made, and they speak for themselves.
by what attorney?
From an evidentiary point of view, to place in the record the substance of those objections, which I frankly thought we were going to be given the opportunity if the matter was going to go to that stage. But everything was held in abeyance as a result of the representations that were made by Pike in connection with the location of his fence. And that matter still stands today. Only now am I told that he has apparently repeated.
Ascertain, sir, what attorney represented to you that this was going to be adjourned?
I'm sorry?
The mayor asked which attorney advised you that this was
Beth
going to be.
Beth Goldman. I can read her email. Do you want? I can read her email.
What do you say?
You can read
Beth
her
Baldwin.
email.
So
Beth Baldwin from,
Beth Baldwin does not represent us.
No, represents Jim Pike.
Well, then you take it up with her.
Well, that's not fair, by the way. She represents the applicant, and therefore it was if the applicant spoke to me and said, "I'm adjourning until February," as if he said it. I have it on the record. I'm sorry, I have it on the email, I should say.
unfortunately, the applicant's attorney doesn't control the agenda for the village.
Well, what may I say, by the way, since the applicant is not here to prosecute it, it still seems unfair that the matter is being considered today as opposed to it being considered in February with the applicant present. Let the applicant come forward and refute the discussions that were said with his neighbors on Labor Day, the agreement that he had made that regarding the location of the fence on the south side. Let him come in and refute it.
This has been going on for a year, sir.
But may I say, though, in large measure, it wasn't, there was things that were going, by the way, and there was many reasons why it was taking this amount of time. Many reasons. One one reason I must tell you from my perspective is I was not able to speak to Jim Pike's attorney. He kept saying, I have an attorney, speak to my attorney. As I said, I intend to. I said, I shouldn't even be speaking to you.
As far as the board is concerned, Mr. Pike, in this application now, has met all the criteria necessary for us to grant him a permit in the same way we have granted other active farmers 8-foot fence permits many times. And as I say, I encourage you to have negotiations with him. If you are trying to bargain with him, that if he reduces the amount of the cultivation in his field in order to get your permission to cross your rights of way, that is absolutely irrelevant to this board in terms of the application as it stands now.
Well, Mr. Chairman, at a minimum then, listen to what you just said, at a minimum. By the way, I still maintain that matter should be adjourned. Then the application should be granted. There's no reason for him to have an access fence if he is abutting access to what? As soon as he opens up the fence to act, all right, to utilize that access, he's encroaching on someone else's property.
Not if it's opening inward.
I'm sorry?
Not if it's opening inward.
Well, as soon as he steps foot by so much as 1 inch out, he's trespassing. He's trespassing.
Then you will have reason to object to it and to get mitigation.
Correct.
Mr. Chairman, I say again, I respectfully submit, the neighbors have been ambushed in this matter by a sudden turn. Apparently, it's been acknowledged Jim Pike spoke to you, I'm sure that happened. I believe that. But then at the same time thereafter, said the matter was going to be adjourned. I have the communication from the attorney to February. And this is after I spoke to Jim Pike on Monday, last Friday, in the middle of the week and the beginning of the week. He reaffirming at all times that intention, and then stating to me at the last time as well when we were at the meeting last time.
Okay, is there anyone else attending virtually who would like to say anything on this matter?
Yes, Mr. Chairman, Mike Walsh. I'm in attendance. I don't know if you can hear me.
Yes, we can.
Okay. I'd just like to make one point. I noticed on your agenda today that this matter was calendared apparently for the express purpose, Mr. Chairman. I'm going to read from the agenda. Applicant will provide the board with an update on his progress with neighboring property owners and location of the access gates for the farm field. I've attended every meeting, Mr. Chairman, and I've been on top of this matter since the inception. My group's concern, and we are the Lumet subdivision owners to the north. Marcia Michon is my client. Our concern is the use of the adjoining common driveway area immediately to the north of the ag reserve. And we've put a lot of writings in, and we've made, I thought, a lot of progress in trying to resolve this issue of access. And we were guided by the board throughout these proceedings and encouraged by yourself, Mr. Chairman, Mr. Mayor, to proceed to talk to the neighbors and try to work this all out, which we did. We came to finalizing a plan that would provide access to Mr. Pike, and it would result in a slight amendment of the subdivision covenants and restrictions, but as regards the common driveways. But our concern all along has been that Mr. Pike not use the adjoining property as access to the ag reserve. The fence, the fence is the fence. We're not too concerned with the fence, quite frankly. We understand he's moved it in 10 feet. My clients are willing to live with that. This has really been about access more than the fence from the inception of our attendance at these meetings. But I just want to point out in response to your council's question, which is, pretty much how do we get here and why is Mr. Boravina complaining about the fact that it was to be adjourned? I was also advised it was to be adjourned, but here I am. You can't attend and complain about not being on notice and not being able to attend. Here we are. We got here because your board encouraged us to work with Mr. Pike, and we bent over backwards to try to help him out with his access. So our concern, at least the neighbors to the north, I think Mr. Boravina's clients, the Claudio subdivision owners, have different concerns. They own these flag posts to the south, approximately 100 feet in width. If you add them all up, 25, 25, 25, and 25, 4 lots. His concern may be different, but if you permit this to go forward and the site plan to be approved, you're in essence permitting Mr. Pike to pass and repass across property he does not own, both to the south and the north. And I would just request that the board address that issue either as part of their approval or give us time to further converse with Mr. Pike. My understanding is from his attorney that he does not want to proceed with our version of the settlement agreement and the amendment of the covenants and restrictions, but maybe he has another idea. Right now, it seems to me you're going to grant him a site plan which permits him to pass and repass over property that he does not own. And I'm not so sure that that would be in the best interest of either the village or the neighbors.
You let him in.
But by the way, if I'm, Mr. Chairman, let me underscore, it is absolutely right. At all relevant times, Mr. Tohill had said, and the board had said, that this matter was really subject to the discussions that were taking place with neighbors and Mr. Pike regarding a resolution of his application. That's how we were proceeding. And only now am I told today, actually yesterday to be more accurate, that contrary to a written representation on Monday that it was going forward on, that the matter is going to be adjourned on until February, lo and behold, it's going on today. And by the way, very interesting, it's going on rather curious. Not even the applicant is present today.
Yes, he is.
Her attorney.
He has just arrived.
For the record, Jim Pike has just come into the meeting room.
Who?
Jim Pike, the
Oh.
applicant, has just arrived in the meeting room.
Okay, all right, good. All right, so now he's here. And my objection still stands. There were representations by him regarding an agreement. I'm saying this now in his presence. He said it to me several times. He said it on Labor Day weekend. He said it thereafter when I confirmed it. He said it when we were meeting with before the board last go around. He said it outside the meeting of the board. He said it to me last week. I spoke to the attorney, Beth Baldwin. She understood and agreed with that position. It was all subject to negotiation, and that's how we were all proceeding. And now, only now, out of thin air, am I now told, for some reason, it has to proceed today. And whereas I was told on Monday it was going to be adjourned. And by the way, I'm now repeating myself, but Mr. Chairman, I'm doing it for the benefit of Mr. Pike, so that he listens to the point that's being made, and he knows that what I am saying is correct. And he knows that this matter was at his own request to his attorney, who turned and told it to me, the matter was going to be adjourned till February.
Thank you, Mr. Boravina. Is there anybody else who wishes to speak?
Yes, Eric Bregman, good afternoon. Can you hear me?
Yes.
Okay. I don't know if you can see me or not. Maybe that's not such a great thing anyway, but.
We can see you in profile.
Okay. I just wanted to say a couple of things for the record. One, Jane Kratz and I represent respectively the immediately adjacent flag to the south, the first one, and the second one, which you can see on the map that's at least on my screen. I think Anton represents the other.
Eric, can you identify the property owners of those flag strips you just referenced?
Yes, they are. Um, They're LLCs, but I can tell you the LLC's name are, the first property strip goes to SAG LLC. And that's owned by, and the members are the Zeises.
What is the address?
If you give me 1 second, I think it's 750. One second, please. I believe it is 750 or 760. That's Jane's client, which is why I'm not sure. My client owns the second flag from the reserve, and that's owned by 770 Main LLC, and the owner of that is John Papp, and that is, as from the name you can tell, it's 770 Sag Main Street. So I think the addresses of the 4 lots going from north to south are 740, 750, 760, and 770. And if you give me a minute, I can look that up, but I believe that's right.
So what are your objections?
Yeah, I actually don't have an objection. What I do want to, and hope you will make clear in the decision, is that if this fence were installed, it does not give Mr. Pike any right to use any of the flags either to the south or to the north. What has been discussed, and I think would be terrific for everybody, is that the neighbors to the north will use, the flags to the north will be used by all the neighbors, and the 2 flags to the south, the SAG LLC and 770 Main LLC, will grant Mr. Pike access along those flags. And I don't know how that fits in with Mr. Borovino's clients exactly, but that's something that is in the fine tuning stage. The main thing, though, is that assuming that the fence is where it is shown on this plan, and the gate is where it's shown on the plan, Mr. Pike would have access going down his 10-foot strip to that gate. But I hope your decision will make it clear he doesn't have any right to go north of that 10-foot strip.
You will
or
make
anywhere.
that clear.
Okay, that's the point I wanted to make. Thank you.
And Mr. Chairman, Mike Walsh, I would make the same application as Mr. Bregman on behalf of the owners to the south, that Mr. Pike would use the 10-foot, excuse me, on the north, the 10-foot strip on the, he has 2 10-foot strips that he would be limited to those 2 10-foot strips as access, and he would not have use of any adjoining properties. I would basically take the same position as Mr. Bregman has very cogently laid out for your board.
That will be included in the resolution of approval.
Well, but Mr. Chairman, by the way, Mr. Pike is present, and what is it?
Who is speaking?
This is Anton Borovina. If I may, Mr. Chairman, with Mr. Pike present, what is his intention with respect to utilizing access either to the north or to the south side to get to Saguenay?
Well, may I interrupt for 1 second, Mr. Chairman? I mean, the intention of, this is Eric Bregman. I'm sorry. I should have identified myself. What has been under discussion has been an agreement, and one reason to do the adjournment is to work out the fine tuning. But my clients are conceptually at least willing to give access to Mr. Pike across the 2 southern flags immediately adjacent to the reserve. I shouldn't say my clients. One of them is my client and one is Ms. Kratz's client.
I think Mr. Bregman,
Yes.
who owns the right of way immediately to the south of the Mr. Pike's parcel?
That is SAG LLC and Mr. and Mrs. Zeises, ZISES, and Jane Kratz is their lawyer, and I'm
All right, okay.
appearing for her as well. And then my client owns the next one over, the next one south.
If you are willing to give Mr. Pike permission to use one or both of those rights of way, I'm sure he would appreciate it. But it's for you to work that out with Mr. Pike.
And I hope we do. My only point today is simply that nothing that happens here today is intended or would give him any rights to use that until we work it out.
Now, by the way,
Either
if
on
I
the
may,
north or the south.
okay, Mr. Chairman, I had asked the question, and Mr. Bregman,
Who is speaking now?
this is Anton Borovina. I had asked the question, and Mr. Bregman wanted to speak, and before the question could be actually asked and then answered, I just want to be able to, with Mr. Pike present, he can clarify what is his intention of access on the north and south side to get to Snagman.
I think you have had more than enough time, measured in many months, to discuss this with Mr. Pike. And you still can, whether we approve this or not. Obviously, if we don't approve it, then there'll be no question. But there still may be a question about access to that field, whether there's a fence on it or not. So I really, it bewilders me as to why you're opposing installation of the fence. If it's because you're afraid that somebody might use these other rights of way to access the field, that exists now, as I understand it.
Well, that, by the way, no, it doesn't exist now, but in any event, the complaint is with respect to the construction of a fence, and there are neighbors who wanted to be given the opportunity to evidence the alternatives. Mr. Pike said, before discussions took place, and before your meetings were adjourned to take into account those discussions between the neighbors, Mr. Pike gave his view.
11 months to submit evidence to the other alternatives. The board has considered other alternatives, not just for this application, but for at least a half a dozen others that we've had over the past 3 or 4 years. And the board has determined that the alternatives that currently exist, whether they're double fencing at lower heights, whether they're electric, whether they're cantilevered, they do not provide the same protection to the farm crop as the alternatives. And this is historically a farming community, and we believe in the right to farm, and we believe that a farmer has the right to protect his crops in the same way that non-farmers have the right to protect their homes.
And Mr. Chairman, I can say, I can't speak for the other applications. I can say that I've spoken to others who have done this kind of research, and including, by the way, the prevention of deer penetration onto farms and other areas to be protected. And there are suitable alternatives. I can have them discussed and presented. At the next.
Agreed, there are other alternatives, Mr. Borovino. It's a question of the effectiveness of the alternatives.
I'm sorry, say it again. I didn't hear you.
We agree that there are alternatives. The question is not whether there are alternatives. It's the effectiveness of the alternatives.
Well, that's a good question, and that's to be discussed. Exactly, that's to be laid out, of course.
Has been discussed. The board has considered it. Is there anyone else who wishes to speak on this application? If not, let me just pull the the board. We have a resolution, which I will read if you approve, to grant Mr. Pike a fence around the perimeter of his property with gates, giving him access from the rights of way that he owns. Should we go ahead with this?
I believe so.
Bill?
Yes.
Marilyn?
Yes.
Lisa?
Yes.
Okay. Let me propose the resolution if I can find it. Where is it?
It's in your plan.
Old business.
Well, Mr. Chairman, I'll sign off if I may. There apparently the board has decided, and I'll discuss matters with my client.
Okay.
Thank you. Have a good day. Bye-bye, gentlemen. Bye-bye.
Bye-bye.
This is an application for an agricultural fence permit pursuant to Village Code, Section 245-49D. The application was filed during January 2021 and has been heard periodically by the board. In each instance, adjourned to allow neighboring objectants and the applicant opportunity to resolve issues relating to access to and from the subject agricultural field from Sagaponack Main Street. The board has determined this application is a type 2 action under New York 617.5C4. The board makes the following findings. The subject premises is a 5.1 acre parcel known and described as Suffolk County Tax Map 0908-5-1-27 and is 824 Sag Main Street. The subject premises is classified as an enhanced farming area under a grant of development rights easement to the town of Southampton. The subject premises is part of New York State Agricultural District number 5. The subject premises contains Class 1 and Class 2 soils as identified under the Soil Survey of Suffolk County. 5, the sole permissible use of the subject premises is agriculture and is so limited under the aforesaid grant of development rights easement. 6, the town of Southampton, as grantee under the aforesaid easement, has on November 30th, 2021, consented to the enclosure of the subject parcel with an 8-foot tall galvanized steel agricultural fence with 2 gates. The town's consent is subject to the village's approval of this application. The location of the proposed fence is as depicted on a certain survey prepared by F. Michael Hemmer, LS, dated March 14, 2016, which is entirely on premises owned by applicant. 9, applicant has owned the subject premises since 2004 and has farmed the parcel since prior to that date as a rental and since that date as an owner. 10, applicant has described to the board without challenge of any objectant significant deer damage and equal loss to crops planted in the premises. 11, applicant has described to the board without challenge of any objectant multiple alternative approaches used to deter deer, none of which has been effective at this site. The subject, 12, upon information and belief, the source being correspondence from counsel for objecting neighbors, the applicant and the neighbors have considered alternative means of ingress and egress.
Don,
Yes,
that is, you should read 12.
excuse me. This is 12. Considered alternative means of ingress and egress to the site
No, wait,
different from,
12 is on the top of the page.
that is not included.
Oh, yes, it is. Yeah, yes, it is. 12 is included. I took the other 12 out.
Oh, excuse
So
me.
read 12, and that's an important 12.
Let me rewind. 12, the subject premises has 2 10-foot access strips from the body of the parcel to Sag Main Street. 13, upon information and belief, the source being correspondence from counsel for objecting neighbors, the applicant and the neighbors have considered alternative means of ingress and egress to the site, different from or in modification of the aforesaid deeded 10-foot strips. 14, the 5.acre field is surrounded by residences and vegetation and is not visible from Sag Main Street. 15, applicant has described to the board without challenge the crops he has planted in the past and his present planting plans. 16, the aforesaid Hemmer survey is deemed sufficient for the board's review of this application. 17, any disposition of this application enabling the installation of the agricultural fence as requested would be subject to its removal as required under Village Code Section 245, 49D, 4A. By reason of the foregoing findings, the board concludes that the applicant has satisfied the standards in Village Code Section 245, 49D, and accordingly it is resolved the board grants this application subject to the requirement that the fence specification be described as in paragraphs 6 and 8 herein above, and that any poles be as described in Village Code Section 245, 49D, or C. And it is further resolved that this approval is subject to the understanding and condition that this approval does not authorize any use of adjacent private property which is not owned by the applicant and is instead owned by third parties, including the objectants herein. And it is further resolved that this approval is not intended to discourage any continuation of negotiations between applicant and objectants toward applicants and objectants' accommodation of respective interests and concerns. And it is further resolved the village clerk shall forthwith send a copy of this resolution to the applicant and his counsel, Elizabeth Baldwin Esquire, and to Anton Borovina Esquire and Michael Walsh Esquire, each counsel for objectives. Can I get a motion to pass that resolution?
So moved.
Second.
All in favor?
Aye.
Unanimously approved. Jim, you have the resolution, you have the approval. Is there anybody here to speak on the Nairi McCray lot modification?
Yes, Joe Lombardi from the Rayner Group.
Oh, okay.
Joe, could you put your video on? There you are.
Here we are.
There.
And Nairi is with me.
All right.
Hi, Nara.
Hi there.
Hi.
Hi, everybody.
I just would like to explain to the board why you were seeking this modification. This is basically, we all have it in our packages. A map is shown on the screen. It is carving out a portion of the easterly lot on Sag Main Street and transferring that portion to an adjoining lot, which is accessed on a flag strip. So why are you asking for this?
Okay, one of the reasons is to,
Excuse me, Joe, can you just identify yourself for the record?
sure,
Thank you.
Joe Lombardi for the Rayner Group. And we represent Nairi McCray in this application. The purpose of this lot line modification is to eliminate a nonconformity because of the lot being a flag lot. The floor area calculation resulted in there being an actual overage on the property of something akin to 600 square feet.
This is on which property? The
274.
This is on the 274, which is the back parcel, the interior parcel.
the interior.
Joe, could you identify them as lot 1 and lot 2, because that's how they are represented on the map?
Sure. Okay. Lot 1, which is 274 Sag Main, is the parcel that has a slight overage in the amount of square footage that exists on the property. As you know, as there have been so many changes due to COVID, one of the things that happened was the existing garage is more or less utilized as a gymnasium. And they would like to construct an additional garage or a new garage to replace that garage. They can't do that right now because they don't have the area that's necessary. And that's the purpose for the transfer.
And this is
Can I add
because-
something?
Oh, Nairi would like to say something.
Hi, this is Irene McCrae. Hello, everybody.
Hi.
This request that happened in COVID was actually originally there were 2 lots, and lot 2 was merged with what we are now seeking to change over to lot 1.
Could you say that again?
You have that subdivision map? The original subdivision map?
This one?
No, there was a lot that was created as part of the original subdivision. And that lot was actually merged to the 294 lot,
What lot number?
which is lot number 2.
So that left the lot number 2, a 4-acre parcel with a very small house, and lot number, relatively small, excuse me, and lot number 1.
If you could just go back a little bit.
These are the subdivision maps, Joe.
Okay.
So do you want me to, these were the original 1, 2.
One that's the, yeah.
That
see,
was merged with the with lot number 2.
Okay, hang on, I'm gonna give you the one where,
hold on.
I think that's what you want. Is that what you
Yes.
want?
Okay, so that left lot number 2, 4 acres, lot number 1, which was originally conforming, and then when the what's it called?
Flag strip.
Sorry, when the flag strip was deemed to be not counted, we went into the red. So at the time of building the house, there was an overage. There was not an overage. There was sufficient for some other buildings to be built. Then they were eliminated. So this would even it out. Each lot would be about 3 acres. And the central part that we're trying to move over to 1 would then become part of the green space. And I would put a conservation easement on that so that although it counts as lot number 1, they can't build on it. And of course, neither can lot number 2, because lot number 2 will have lost, it will have been taken away. So it precludes anybody being able to build on that corner, but it doesn't stop the owners of the buildings that exist extending modestly in the future if they need to. That's all of it.
If you carve off the piece on the map, what is the acreage of the remainder of lot 2?
No, it's, let's see.
Lot 2 is 4 acres as is now.
Well,
Yes,
But,
now,
well, yeah, lot 2 is 137,000 square feet,
Yeah.
begin
What's
with,
2.5 acres.
okay? And lot 1 is 122,865 square feet,
that? And that's
okay?
how many acres is
So
that?
what would the size of lot 2 become?
Lot 2 would be reduced to 80,119 square feet.
Which is,
It's 2 acres.
It's a 2-acre zone, so it meets the requirement for the area requirement for the 2-acre zone.
Well, what I find problematic here is if this subdivision is granted, the resulting lot 1 would become subdividable.
There could certainly be, there's no intention to subdivide it, and there could certainly be a,
So if we did it, we could condition it on a covenant that there will be no subdivision.
yeah, no, that's fine, and as Nairi spoke before, she's willing to put an easement over that area that's to be transferred so that it can't be built on. So that would eliminate the possibility of a future subdivision.
No, but it just limited what could be done with that part of the lot.
well, I certainly would be willing to agree that that cannot be subdivided again. This is part of the major.
All right, and then would you also be willing to put a covenant on lot 2 that an understanding that no dimensional variances will be granted on lot 2?
Yeah, absolutely.
Yeah, that's fine.
Yeah, the whole purpose of this is to just preserve pretty much what is with a little
Okay.
flexibility.
Okay. Now, the other problem is access. Clearly, as is laid out in the subdivision plan, access to these 2 flag lots from Sag Main Street would be difficult, if not impossible, since there's about a 10-foot drop from the edge of pavement to the supposed rights of way. So as indicated on the survey, there have been alternative access to the flag lots to the north, seem to share access with lot number 1.
No, they don't. They want each lot, at least, I don't believe, there are, each lot, starting at the back, has its own drive.
Mhm.
And then,
It's not,
there's
that is
one
not shown in, it's not shown in the survey.
well, because it belongs to the lot.
Once
The lot, each lot has a drive going out to Sag Main.
No,
So there's 60 feet of driveway, of land allocated for the driveways but instead of putting in 3 driveways side by side.
I understand, but is there any legal documents guaranteeing rights of way?
Yes, when the house was built, when,
Could you submit those to the board, please?
well, I'm not sure that it guarantees, but the lot 270 at the back, and then lot number 1, and then lot number 2, all have approved driveways. Lot number 2 only shares the access to Sag Main Street. lot numbers 1 and,
But the road, the driveway that is being used now by the interior of lot number 1,
yes,
also by another house that's not shown on the survey, but there's a right of way to it.
the one, they are all using 270. They're all using the driveway that comes off the house at 270 Sag Main Street.
There is one driveway that serves all 3 lots.
But
the-
we would have to see some documentation.
Okay.
That those driveways, those access points are the ownership of them, or the easement to use them exists on paper.
Division map that I think that you have.
Oh, can you,
No, there was a 20-foot wide easement for ingress and egress that was provided on the subdivision map. If you want documentation, we will.
Yeah.
We'll obtain documentation for it.
That's all I'm saying. We're meddling in a subdivision that has already been done. And in so doing, this then becomes an official village action. And we need to have some assurance that since it is virtually impossible, if not impractical, to have the access points as shown on the original subdivision map, that there be some easements.
the easements, if they don't exist, we're very happy to have them exist. That's, the driveway was never, there's no way the driveways could be changed from the way they are now.
And there was never an intention, even when the subdivision was initially done, to have individual driveways for each of these flag strips. There's always been a common driveway.
Joe,
Yes,
we would like, as part of this approval process, to have attached the documents showing that lot number 1 and the other lot, which has no name, but also is taking access from that common point, has the right of easement to use that property for access.
okay.
It should be
There's
shown.
no objection to that. We'll be able to provide that. Now, would that be a condition of an approval, or do you want the
Yes.
document? Okay, so it would be a condition of an approval that in addition to filing the deeds that would create the transfer and create the proposed lots, we would also file a common driveway and utility easement for
Yes.
all of those lots.
Yes, and they should be,
Okay.
that easement should be shown and earmarked as for what it is on the survey.
Sure, that's not a problem.
Bill, you got any questions on this?
No questions.
Marilyn,
No, looks good.
Lisa? Okay, then we'll instruct our attorney to write a decision approving this lot line modification with the 3 conditions that we just enumerated, and we'll adopt it at our next meeting.
And
Thank you very much.
just so that I'm clear, there, we are not requesting the documents, the driveway easement documents before next February's meeting.
Well, we're gonna have to review them. They're gonna have to be submitted in time for us to review the documents.
So if they do exist, Joe,
Yes,
if they do exist out there, then submit them to the office and I'll submit them to the attorney.
Yep. If
they don't exist, then they have to be drafted, in which case send me a draft, which I'll also put before the attorney, before
Right.
the February meeting.
And we should do the declaration of covenants and restrictions for those three items that we talked about
Yes.
that were consented to by the applicant as well.
And we should, and you should update your survey to show
Yes,
the easement area.
okay.
Irene, you got anything more to say?
No, thank you very much. That sounds good. We'll get our ducks in order.
Thank you very much.
Thank you.
Thank you.
I'm going to do a motion to adjourn this to the February 9th meeting.
Yes, can I get a motion to adjourn this to the February meeting? Where we should have a resolution prepared. to, implement.
Second.
All in favor?
Aye.
Aye.
Okay, we've done the agricultural fence. So we're moving on to the monthly work session.
Mr. Chairman, Mr. Mayor, I'm sorry. I don't know if you did number 2, Wilford Trust. I got on late because the link wasn't working correctly. Mike
Good.
Walsh.
We did do the Wilford Trust.
Okay, that was done. That was before I got on then. Okay.
I did.
And that was extended for the 90 days, I assume?
Assume nothing. We will give you a 90-day extension. It will be the last extension. If you cannot submit a complete application by 30 days before the 90-day time limit, the subdivision approval, preliminary approval is going to lapse. There will be no more extensions. It is up to you and your office, or if not, some other competent attorney, to complete this application in a form that we can approve it with you doing the work, not us.
That was, you said 30 days before the 90-day
You will be given,
deadline. Is that what you said? I'm sorry.
pardon?
Okay.
30 days.
Thank you very much.
We will give you a memorandum, just giving a few brief objections to what you submitted and what is not there. Schedules aren't there, signatures aren't there, tax identification numbers are not there. Wording of some agreed conditions have been altered to change, perhaps unwittingly, some of the conditions that we were going to put on the pairing of lots. You will be given a brief memo, not comprehensive, but just on the most glaring deficiencies. And it's bewildering, frankly, that, that this, it's just sloppy work.
Mr. Chairman, you know, I've been putting everything in writing and I'm going to continue to do that. And I will have, I assure you, a specific and comprehensive writing in your file. We've already partially responded. So rather than split hairs here and getting into a contest over completion, I'll put it in writing. I appreciate the extension. My client appreciates the extension. And I assure you that we will make all the appropriate filings. That's all I'm going to say today. But we will do that in writing, Mr. Chairman, pursuant to your instructions, and we appreciate the extension.
But you do understand this is going to be the last extension.
That's what I heard. I assume I'm going to get a resolution, and as I said, we will make great efforts to comply with your requests.
Thank you.
Thank you very much.
I get a motion to adjourn this application until for 90 days.
You had
We
previously
already
done
did.
that, Don.
Pardon?
You had previously done that. You had already previously
Oh, we
addressed that.
did.
We didn't.
Yeah.
And the resolution notes that this will be the last extension granted on this matter and the 30-day deadline for the submission. Okay, thank you, Mr. Walsh.
Thank you very much.
Moving on. We'll wait and do minutes approval next month. I did read the minutes and they seemed to be fine by me.
We've got one set, I'm working on the second one, you'll have that for next week's meeting.
Okay. Town Police Department report. Mary, I'll give you the opportunity if you want.
Yes, basically, we look in the summary. Nothing new. Overall, for the whole year, there were 99 abandoned 911 calls. I'm just going to pick up the highlights. 41 accidents with no personal injury. 32 aided cases, 182 burglar alarms, 187 fire alarms, 29 alarm car monoxides, 19 medical alarms, 15 panic alarms, 96 ambulance calls, 29 animal complaints, assisted handicapped disabled person 17, 19 check welfare, code enforcement follow-up 8, disabled vehicles 13, fire building 9, fire other 9, 51 ordinance noise complaints, 19 parking complaints, 47 reckless driver complaints, 30 suspicious incidents, 32 traffic hazards, 764 traffic stops, and 14 utility wire issues. That's for the whole year. And this month was nothing out of the ordinary.
Okay, we remain violent crime free.
As you like.
But I did hear, Lisa, about some bicycles being stolen.
Pardon?
I heard about some bicycles being stolen.
That's correct. But not my house, my relative. Oh, wait,
Sagaponic?
Yes.
mute. Yeah, so anyway, yes, I did hear that. But I don't think anyone called the police.
Was it in December or January?
No, December for sure.
Oh, well, that's why it's not on here.
Okay, I've got some new business here. I need a resolution to appoint Anthony Pasca. Let me get this thing off. Anthony Pasca, as special counsel to represent the CBA with respect to the Trillo application. Can I get a motion to make that appointment?
So moved.
Second,
All in favor? Aye.
aye.
We have an application here for the keeping of chickens, 16 Old Barn Lane.
Done in the meeting room is Andrew, who just came on, and also Stephen Kiley. Your microphone and your video is off. If you could join us in the meeting. And there's Stephen Kiley.
First, I'd like to just go over the code. And whether or not they have been met.
Okay.
What is it?
I put the code in your book and I put the application in your book. When there's new business,
I'm looking.
there's your code. And it's D, keeping of chicken.
C,
C.
All right, just so we're all familiar with this. We don't have too many of these applications. Uh, okay, the number of chickens shall not exceed 6 per 20,000 square foot of lot area. What's the size of this lot?
There's your applicant up there. Andrew?
Just a second, I'm gonna get the number. I didn't have that handy. It's 73,631 square feet.
So, all right. And how many chickens are you applying for?
5.
That is substantially under the allotment. Will there be any commercial sale of these chickens or the chickens themselves? You understand that roosters are prohibited?
I'm sorry?
Do you understand that roosters are prohibited?
Yes, I do.
Roosters don't. On your plan, what is the size of your chicken co-op structure?
The size of, say it again, is it the chicken run or tell me?
For the coop, well, for the hen house.
Oh, so the hen house is 8 by 12.
So 96 square feet.
Yeah.
And what's the height of it?
I'm sorry?
Height,
How tall is it?
Oh, how tall is it? I believe it's less than 10 feet, which was the maximum, I think.
okay, you understand that that is the maximum. And the setback, I saw on the survey, it is greater than 30.
Right.
Neighboring property owner.
So it's approximately 34 feet and the minimum is 30. And I should note at this point, that's a bit further away than where it is now, since it was unintentionally built without a permit, or they didn't realize they needed one.
All right, but as shown here on the survey, it will be 34 feet 1 inch from the, I guess, northern side of the property.
Right. Yes,
And they will be a fenced-in chicken run.
I'm sorry?
It shows a chicken run.
Right. And the chicken run, I'm sorry, we don't have a dimension, but that's
There is no dimensional requirement for that, so. Okay, so tell us, why do you want this chicken permit?
Well, I mean, they want a permit to keep chickens and have fresh eggs, and they have 2 young children that enjoy the chickens, and they enjoy their fresh eggs.
Did anybody here have any questions of the applicant as to what he's planning to do?
Mr. Kiley is representing the neighbor.
Okay, Mr. Kiley.
Good afternoon, Mr. Mayor and rest of the board. Can you hear me all right?
Yes.
I also want to say hi to Mr. Egan. Pleasure seeing you as well. Haven't seen you in a while.
Oh, Steve.
Yeah. My name is Stephen Kiley. My office is located at 12850 Main Road, Mattatuck, New York. I'm the attorney for the adjoining neighbors to the north the Solomons, who are a founding family of the village and have resided here since prior to the village's inception. They've grown accustomed to the residential character of the neighborhood, and here the applicant is attempting to change that character. My client knows of no other neighbors in the community that have chickens. That being said, my clients have no objection to the applicant actually having the chickens, but rather that said chickens are kept in a manner that is both neighborly and courteous. This proposal is the exact antithesis. The applicant is seeking to locate the coop 34 feet from the shared lot line and have a run that is significantly closer. I don't even know the distance. It's not on the survey. My best guess is maybe 15 to 17 feet away from the shared lot line. I've had chickens myself. I'm here on the North Fork. We're a rural area, and I've had up to 26 chickens. And the area that is the noisiest, dirtiest, smelliest, and used during daylight hours is the run. The coop is where they go to sleep and lay eggs. So at the minimum, I would argue the pen should hold the 30 feet as well. I would argue that the exclusivity provision of section 245-35C4 only applies to the size and the height of the pen, but that's arguable. But what is not arguable, and what is as clear as day, is that there's a significant amount of room on this property to locate the coop and the pen in a way that doesn't negatively impact my client. West off of the planter deck, there is plenty of space for the proposed coop and run that would greatly minimize or eliminate any negative harm to my clients. It will still be in the rear yard, and the noise, smell, feathers, dander, dust will be far enough removed from impacting my client. It should be noted that chickens attract vermin and rodents. And again, moving the source of said attraction away from the shared lot line would be the appropriate thing to do. While the requisite authorization in section 145-34C is referred to as a special permit, it is really a special exception. And as such, the board must determine that the standards enunciated in section 245-57 are met. The most applicable being 245-57C, which states that the proposed use will not prevent or impair the orderly and reasonable use of adjacent properties. Here, undoubtedly, this use will impair the reasonable use of my client's property by creating a nuisance and negatively impacting the use of my client's outdoor space, which again may easily be ameliorated by simply moving the coop and the run. Also, this board pursuant to section 245-57J needs to ensure that there are adequate buffer yards to protect adjacent properties. If the minimum 30 feet for the coop is inadequate and the approximately 15 to 17 feet for the run is inadequate, the board may impose a larger setback. If this board did not have any standards, why are we even here? Why are we having a public hearing? If all they had to do was meet the conditions and ministerially get the coop, why have the public hearing? That would, in my mind, be nonsensical, and any standard list determination after a public hearing on this application would be by definition arbitrary and capricious. So in sum, I would respectfully request that the board require the coop and the run be relocated to the other side of the rear yard, which again would ensure that the chickens do not have a negative impact on my clients, and the applicant can still have their chickens and have their eggs, and everybody can live in harmony. So that's my request.
Anyone on the board wish to address this?
So this house is on the corner of Old Dorm Lane and Hedges.
Where's an old bar? Ted Griffin lived there for many years.
And they'd like to see the hen house and the chicken run closer to the road, I guess.
Well, it's my understanding, I'm sorry, did I interrupt somebody?
Yeah, you said you would just like it moved further away? What do you think would be an adequate distance?
Yes, Mr. Mayor. So in my, and I corroborated this with Mr. Woodsma, there's 2 front yards, obviously, because this is a corner lot. So the coop couldn't be within the second front yard, which is off Hedges Lane. So if you drew a line perpendicular to the house, and you see where the planter deck is,
Yeah,
I would just say, west of that, and there you'd be in the middle of the property, set back enough from the hedges, set back more than enough from my client's lot line, and I think everybody'd be happy. And to me, I wouldn't want chickens next to the pool area, because again, there's feathers, there's dust, and so it would make more sense to be by the planter deck. But that's just me. Of course, the best and most ideal location would be in that front yard, but I would assume that would necessitate a variance. And we're not asking for that. We're just asking for them to put it on the other side of the rear yard.
Rhoda, can you put this up?
what's west of the property? Is that a driveway? Or is that a flag lot?
Just driveway.
West of the driveway? West
Oh,
of,
on the left-hand side, I think that's a flag line.
okay.
I'm getting there, yeah.
There seems to be an awful large, thick hedge or some sort of vegetation that lines where that end and run is proposed. And I would think that that would be sufficient to block it from being annoying to the neighbors.
I would argue, yes, it screens it, and my clients do not have to see the chickens, but it's not going to prevent smells. It's not going to prevent dust and dander from elevating in the air on a windy day and going over. It's just, again, all we're asking them to do is be neighborly and move it, again, a little further away from the shared lot line. The other lot line is a road. The other lot line, well, 2 lot lines are roads, one's a pole, and it seems like they're squeezing it right up against an improved parcel. And it's just, again, I don't think it's a big ask to have it moved.
What is on the property? What is, are these gardens, or vegetable gardens, or flower gardens that to the west of the pool swimming pool?
Looks like vegetable gardens.
It's vegetable garden.
Both of those squares?
On the left-hand side of the fence is a vegetable garden. Left-hand side of the pool, excuse me. Or the western side of the pool.
Yeah.
What would this be?
Oh, I don't know what that is.
That's what you're looking at, that I have up on the screen?
Yeah, what's at the top? This looks like there's a vegetable garden or something, and then a little shed, which is not shown on the survey.
There's a square of vegetable gardening, and then what's north of that?
What is that building there?
Andrew, is that the chicken run?
That's the chicken run. That is behind the vegetable garden. And next to that shed. So there's a pool house, right? There's a pool house right by the pool.
Well,
And then you'll see those
are you asking us to
westerly or towards the left on the screen, there's those 2 lounge chairs. And then the vegetable gardens below and the chicken run above, next to where the shed is now, but that's not where, it is going to be moved further away from the property line.
So all of this was constructed without a permit?
I would say, yes, the chicken run and the hen house was built inadvertently built without permit. They just didn't have any idea that required one. We do have other work going on in the house with permit, and they just didn't realize this was,
But is the answer to my question, yes, these were built without a permit?
correct.
And there are chickens there now?
I'm not sure if right now in the winter there is or not, but
Well, I
there
don't
was.
mean that in the winter, that it has been used as a hen house and a chicken run.
Yes, sir.
Have we had any complaints from the neighbors?
No. What's on the other side, on the Solomon side? What exactly is there? How far away is their house and their pool and their driveway?
Well, do you have an aerial you could pull up?
Yeah. Oh,
I can, hang on, I got to pull it this minute.
Mr. Chairman, if I may, that chicken run looks a little more like a structure than a plain vanilla run to me.
Looks like a lot.
It looks more like a structure than a plain vanilla run. Plain vanilla run is just fencing. And that has, it looks like a roof of some sort, whether it's mesh, and it has, but be that as it may, it's still, in my mind, too close to the lot line.
And does that go right up to the property line? Well, in any rate, so that will be removed?
It does have a mesh top, and it has very light framing to hold that mesh top. But I'm not sure.
Were there
I would
chickens?
not call it a structure.
Has it been used as a chicken run?
Yeah, and may I would say something about
Could
the
you answer that,
location.
please? Could you answer that question?
Yes,
Has it
it's,
been used as a chicken run?
yes, the answer is yes.
yes, it is, sir. Yes.
So their pool is way in the back.
Yeah. But it's somewhere near the house.
Can you get closer?
I can, but then I start to lose clarity. Let's see.
And did the homeowner build it, or was it there when she bought the property?
As far as I know, the shed was there, and the hen house and the chicken run was built.
Well, if they have a wedding there with a tent right in the middle, that's a problem, probably.
Could I say something about the location?
Yes. Which one of you is asking?
That's Andrew Caracciolo.
Yeah.
I'd like to point out while we're looking at this, that the location of that chicken run and where it is now and the hen house, which we will move away, is pretty far away from their house and their pool. And moving it to where the neighbor's suggestion would just put it very close to our house, to my client's house. And I'm not sure, that it wouldn't be any further away from the adjacent home.
But it's their chickens, so if they want to have them, they should bear the brunt of any negative impacts. My client, as you can see from the aerial, there's a little fire pit with a congregating area. They do frisbee, they have volleyball, they do things in the backyard over there. And again, it's just when there is a viable alternative, I don't see why it can't just be moved simply.
With all due respect, I think that would negatively impact my client without doing really any added value to the adjacent property owner.
What did he say?
He said it
Well,
would negatively impact his client and not have a positive impact on the neighbors.
Thank you. Yes.
And again, I'd like to reiterate that I have owned chickens and they, again, are noisy. They attract rats. There's dander, there's dust, there's feathers, and the further away, the better for my client. And again, there's an expansive amount of space that they can put that coop and run that wouldn't have an impact on my client.
There you go. That's good. Mhm. I think maybe they could look into moving it.
I do too.
Mhm.
I mean, how do you feel about this, Bill?
I have no problem with it whatsoever, because I think the vegetation, they're only talking about 5 chickens. I mean, it's not like there's going to be a big poultry production here. You know, the kid's gonna get bored with it, the chickens will leave.
The,
Be different if there was I don't think they'll be able to even see the coop and pen from the neighbor's house.
talking about the noise and the smell other than the smell site.
There's probably more noise coming from pools than there are from a chicken yard.
And with all due respect, the code allows them to have up to 18. And right now they're saying they'll have 5, but they can have up to 18. And I want to protect against that possibility. And again, it has nothing to do with looking at the chickens. It has to do with dust, sound, and feathers and rodents.
You said, Mr. Kiley, that you described the Solomons as a founding family, which makes me think that they lived there at least 10 years. The chicken coop looks like it's been established. For how long, I don't know. Do you know?
Oh, I have no idea.
If it's such a nuisance, why has there been no complaints over all this time?
Again, I don't even know if they've had chickens there yet. They could.
All right, then
Let me see.
I can't
Give you a timeline.
read your name, the attorney for the applicant. Do you know how long this has been used as a place for chickens?
So Don, what I just put up there is September 2019.
Oh, okay.
And
There's no chicken run.
so there's no chicken run there. This is April of 2021, so somewhere in that year and a half time frame.
Pandemic
it
chickens.
was installed.
And again,
I
that's
think,
the structure. I don't see any, there's no proof that there's actually chickens there yet.
Can I make a suggestion?
Sure.
To both attorneys? It might be a good idea that the two neighbors talk and we adjourn this until next month when they've had that opportunity, because it appears to me that the two sides, and granted, we're talking to two attorneys, not the two owners who might have been listening to the chickens from the other side, et cetera, might benefit from having a discussion among themselves first. And then the questions when we ask, how long have the chickens been there? Has the person you represent, I'm just giving examples, have they had a problem with them previously? I think we could clarify a lot of this if the two people that are represented by the attorneys, the two neighbors actually have a discussion, and then next month we approach it. It doesn't appear that the two parties have discussed this, and I'm taking this note, and the board will understand where I'm coming from. This is a Joy Seeger suggestion.
Just for the record, I did reach out to try to speak to the applicant directly. And also my client has spoke, and respectfully, he's an architect, which maybe I should have became an architect in hindsight, but not an attorney. So we don't want to cast aspersions on him because he's not an attorney. But I did try to reach out again to the applicant. They had no interest in speaking. I reached out to the attorney for the applicant, no interest in speaking. And I believe my client, before I got retained, reached out to the architect to try to talk to him. And we were just told to come here and voice our concerns at the hearing.
All right, but you're not able to answer the questions that are being asked you, nor is the applicant's attorney able to answer how long the chicken coop has been there and any of those questions. So what I am suggesting is an adjournment for a month until everybody can collect that information and possibly talk to each other as two neighbors, whether the attorneys are present. Excuse me, sir?
May I say something? For the record, by the way, I am an architect, and I am the applicant, not an attorney. Andrew Caracciolo, by the way. And then I did speak with the attorney for the adjacent owner, this gentleman, Stephen, I'm sorry, I don't have your last name handy. And it was just a few days ago, and I did explain that we didn't have any time to make any changes or discuss a change until a board meeting. And I did speak to your client as well and told them that they could both come and voice their concerns. So if you were expecting I would do more than that, I'm sorry. And we are happy to, I'm happy to discuss this with my client and have it adjourned and see if we can't come up with something that that makes everyone happy. And just for the record, these chickens, not unsurprisingly, with everybody spending more time at home during COVID, the chickens appeared in the summer of 2020. So they were here for 2 seasons. So without complaints, that means they've gone unnoticed by the adjacent owners. And there is quite a thicket of hedges between the 2 pieces of property. So I think that whole idea of that there's dust and so forth getting over the adjacent owner.
Okay, and I'd just like to make a point to that, and I apologize for wasting the board's time on something as trivial as this. But if you have 4, if let's say they got 2 or 3 or 4 chickens that are young, when you get them when they're young, they're not going to have caused a lot of issues initially. They grow, and then they get territorial and things like that. And then also, again, maybe there were not any issues thus far, if there was 4 or 5, but they can have up to 18. And who knows how good they're going to be taking care of these chickens in the future. So why not ameliorate those harms proactively and just simply move the coop on the other side of what I'm looking at is the garden, in essence. I don't know what that, I'm looking at something, looks like a big piece of artwork or something. I'm not sure what that is, but near that could be sufficient. And I have no problem adjourning this and, having some dialogue with the owner. If we can get through to the owner and have some conversations, that would be great.
So,
I like your idea, Lisa, but I think we're gonna be having the same conversation a month from now. And I don't know, I can't really, it doesn't seem to be a big deal to move the damn thing. On the other hand, why should they have to move it? It does comply with what's in our code, and maybe we have a bad code that needs amending, but I guess if they do move that shed 30 feet from the property line, they won't comply. So
So Don, do you want to bring it to a vote at this time, is what you're saying, I guess?
I'd rather not.
Don, this is your work session and your regular meeting is when you usually approve these type of applications would be next week. We're adjourning to February.
Then I move to adjourn it until next week and let the, and see if maybe the two owners can resolve things on their
I'd
own.
rather adjourn it for the month.
Yeah, a month.
All right,
Give
that's
them
fine.
a month to see
Adjourn
if
it
they
for a
can
month.
work out some amicable.
It seems like.
And
the
if
attorneys
not,
have better
and
things
if
to
not,
do
where are they gonna move the
than
shed? If not.
Can I make one request?
The shed.
I'd like to request,
An
oh, sorry.
acre of space, they can move it to somewhere, but there doesn't seem to be any neighbor directly to the west, because it's
Unless you go over.
a flag driveway, I guess. So, I mean, the western boundary.
Yeah, those people right
east-
there.
The western boundary has no real neighbor problem.
Okay, somebody asked a question, Andrew. Andrew's asking a question.
Yeah, I'd like to request that, you know, if we come to some sort of alternate layout by next week, that you don't require a survey for the hearing, because that would be just about impossible for me to get from a surveyor. They're quite backed up at this point. So if it's okay, I'll just come with my own site plans to be verified by a survey.
I'd like to adjourn it for a month, not to next week, to
Oh, for a month, okay.
February 9th.
So we're adjourning for a month, is that what you said? Not next week?
Yeah,
Okay. Okay,
I don't think we require a survey, just do a drawing on the map.
No, we do require a survey because they have to meet setbacks. It is an accessory structure.
If
so they
it
have to-
is clearly what outside of it. I don't.
So,
The building inspector will require a survey.
yeah, for the structure, but not for the run. And
That's
Mr.
correct.
Mr. Crowley's objection is on the run.
That's
So maybe
correct.
we do a hybrid of having, if we modify the survey and we keep the structure, at least the structure is not going to change. We can indicate, as the mayor suggested, perhaps just indicating where the run might be.
Between the structure and the vegetation, maybe,
Mhm,
vegetable garden.
mhm.
You know, we're on the other side of the vegetable garden.
Yeah, the west side, south of the building and west. Yeah, right there.
Yep.
Can you see that, Andrew?
yes,
So perhaps,
I could certainly, I could discuss it with my client.
okay,
And, I mean, I can see why they don't want to put it right in their view shed there from that side of the house.
Yeah, and we're not trying to, like, of course, we'll work with the neighbor. It's just like right there is a little too close for comfort. So we have no problem having some conversations with the neighbor.
Good.
All right, so can I get a motion to adjourn this to our February 9th meeting?
Second.
All in favor?
All right.
Aye.
Thank you all for your time.
All right,
Thank you.
Yes, thank you, everybody.
Thank you.
Not to have a special.
Special events.
Special events? Discussion, yeah.
New business?
No, we're still there.
Oh.
Moving right along. Harry, have you looked at these?
I have.
These are events that are really repeat events.
I've only just gotten here for a year and
No, no,
according,
I'm talking
oh.
Yes, yes, Don. Several times the half marathon, and the cyclamation, which is a bike ride. They have both been here for many years.
What is this under?
The last 2 years, of course, because of COVID, they had it. It's under new business.
Jim, are you waiting here to address the board? Or you just here because you got nothing better to do?
Well, yeah,
He's hanging out.
yeah, I can leave if you'd like.
No, no. Ms. Jim wanted to talk to the board, and.
No, I
Oh.
was just,
Intrigued by the meeting, right, Jim?
yes, see what else you have to deal with.
So, special events.
Yes, so
These have been held regularly.
Yes,
Have we had any complaints about?
no,
No. There's no parking stuff here, or,
no, the one thing that Carrie and I talked about, and I haven't, I have to find out, is with the half marathon. Carrie, you can explain this, you and I discussed it.
the bathrooms, we're not sure about if any are gonna be in the village. It says there are gonna be 5 to 10 bathrooms. And then the next line says 2 to 3 may be located in the village.
I don't recall that in the
So
past.
she's not sure they're gonna be in our village or Bridgehampton
Right,
village.
so I'm gonna get that clarity to find out where they're gonna locate.
Yeah. And there's 600 to 900 people running.
that's gonna go turning on town. Is the track gonna be to Town Line Road on Daniels and then back on Parsonage?
Yeah, it comes
Yep.
in on Sagaponic Road, takes a
Down Main Street.
right on Main Street,
Mhm.
and then goes up around the cemetery on Gibson, down Daniels, up Town Line.
Down Parsonage, then
Sag
again
Main.
Sag Road. Sag Main to Sag Road. And back to Bridgehampton.
To Sagaponic Road, Sag Main to Sagaponic Road.
Right.
Okay.
No bridge lane.
Yay.
Except for one little spot between Ocean Road and Highland Terrace.
But outside the village.
Yeah. There's gonna be 2 tents, which we have nothing to do with, because that's at the BB windmill.
Yep.
No security. Norsec is doing, Norsec is in charge of garbage.
And will there's some,
I'm sorry, Mickey's Carting. Mickey's Carting.
will somebody be policing? Along the track when the race is over.
We don't know that yet. We're gonna find that out.
Well,
Well, it's
great that there are wedding hedges lane.
So we'll get that information for next week, Don.
Okay.
And then,
Same thing with the bicycle.
Now, Cycle Nation only is a letter of intent, so there is no application to act on. They're just letting us know that this is what they intend to do on May 21st.
And who are the beneficiaries of the Bridgehampton Half Marathon?
that says. Stony Brook Southampton Hospital, Bridgehampton School, and Project Most. In Cycle Nation, it's just the American Heart Association. And that's 150 people. Bicycling,
Okay,
Southampton to Montauk.
so you want to get a little more information on this before we vote on
Yes.
it? Move right along. I am presenting to the board a nomination of James. Goes by J. Dobson as an alternate, second alternate member of the zoning board of appeals for a one-year term. Tony has been concerned about attendance there, particularly with this Petrillo case dragging on where John White has to recuse himself. And he thought it would be a good idea if we could have a second alternate to make sure that often applicants before the ZBA want a full board. And so why not be I just met the guy, Elliot recommended him. The biography is in the packet. Brody?
Yes, it is, Don.
If you want, we can wait till next week to make the appointment. When's your meeting, Bill?
Friday.
This Friday?
Yeah.
I'd like to appoint him now, so we can, I mean, want him to attend anyway, but you know how the turnout, what the turnout looks like?
There's two things on the agenda too, so you might want to make sure that he's involved with it.
Okay, well, then can I get a motion to appoint him as a second alternate?
So moved.
Second.
All in favor?
Aye.
Okay, we have here discussion of local law on clarifying the use or occupancy of a dwelling within a single-family residence. So this has been brought on by the specter of timeshare, the equivalent of timeshares in the Hamptons. There was a big full-page ad in the New York Times promoting them. North Haven has been worried about it, and is currently drafting a law to deal with it. I asked the mayor if he'd send me a copy of their draft, and I don't know if they have a draft yet.
She did send it, Don. That's after you got the draft. She told me.
Yeah, but I've never saw their draft.
It just came yesterday.
Okay. I talked to Brian about this a little bit. He said he had some concerns about the definition of family in terms of occupancy. So I'd like to defer further discussion of this to next week. But to address your family, it's really hard to identify what a family is, but it's not so hard to identify what it isn't.
That's definitely true.
So in that sense, I think the burden of proof is going to be to prove that, you know, if it walks like a duck and quacks like a duck, that it's not a duck.
Sure.
We can't control ownership of the property, but we can control the use. And the way this Tony's proposed draft is regulating the use to single family occupancy. And not multi-family occupancy multiple times a year. It's still going to be, if it's, I don't know. I don't know if it's even going to happen. There's a lot of arguments as to how this might not be available. Are timeshares allowed in New York State?
Not as an ownership, not as an issue of ownership of property.
Really?
Maybe benefit.
Because this smacks more of timeshare, where you are part of a group, which your ownership is used for a month.
It commercializes the residential district, which is really what it's not supposed to do. Well, the argument is you get a fractional piece and you own that piece and you're allowed to enjoy it for that piece. But still, what you're doing is you're taking a residential, single-family residence area, now turning it into a transient location, almost like a hotel or a short stay, and it's not really what it's intended to be.
So you think about uh, as I say, I think I want to look at, could you send Brian a copy of that?
Yeah, that'd be great.
Of what, an article?
No,
No, this
North
was
Haven
North Haven's
is
draft.
a draft law that they want to put in there. Mayor is very concerned about it in terms of North Haven, which of course is much higher density than we need.
We can go on picasso.com and
Take a look.
see what it's all about.
We're always trying to come up with a gimmick.
I also have a walk-on resolution, which is largely housekeeping. And one is trying to clear up some loose ends as he disengages. This is basically about Town Line Road, and you're all aware of that right of way from the 1924 subdivision. It has been treated by the Town Highway Department since 1924 as part of the town highway system. Tony looked around to see whether there was ever an acceptance of the road. This was early days. He can't find one, so he suggests that we just do one. So here it is. I'll give you a chance to read it. And this is something that can be done just by simple resolution. And I propose we adopt it. Well,
Yeah.
you guys can't see it.
Let me see if I can pull it up.
Put it
Looking for it, but I can't see it. Okay,
I don't have it.
thanks.
I don't have it, so
put
hang
it on the
on.
board.
Hang on there, Don, I gotta go. Dig it up.
Sorry, I keep forgetting that you're.
You can't forget us.
We're here.
We're here. I don't know if we'll be able to read it clearly, but we can hope.
Very short.
So this is the
Are
road
are
going,
you on a telephone?
I'm on an iPhone, yes.
Hang on.
it's the road going from Daniel South on Town Line that we're talking about,
Oh, yes,
just that portion?
yes.
Okay.
Well, and also, we seem to be a little bit behind anyway on Town Line Road.
Well, maybe up
Because we
to
only have-
Hedges,
Because we only have half of it.
I guess. To go up to Hedges, Hedges or Daniels?
This portion just goes to
Okay.
that. The rest of it, Sagamine Street has been enlarged to that, with, anyway.
All the subdivisions.
Main Street?
No.
The Town Line, yeah.
Read that,
Yes.
I could read it. Yep, thanks.
Yep.
how about you, Lisa?
I can read it. Yes, thank you.
Okay. So, I'll make a motion to adopt this resolution of acceptance. All in favor?
Aye.
Aye.
Okay, we will postpone the financial and claims review to the next meeting. So we'll move on to board committee reports. Lisa, from your perch there in the keys,
Yes.
you have any reports on what's happening in Sacramento?
I do. As you knew from last month, the zoning board did not meet. They'll be meeting this Friday. Petrillo will be again on the agenda. And then a new location this coming Friday, 108 Town Line Road, which is toward the end in that subdivision area where the lots were very thin. But obviously more to follow. I'll tell you next week after they have their meeting. The Architectural Historic and Review Board met on December 21st. And the first item was a driveway gate, and that will go to the committee of two next month. The color of blue was asked to be removed and made cedar, which we've heard before, and assumingly we'll hear what the committee of two approves next month if the color changes and the distance from the road is accepted by the applicant. The committee for two next month will also be reviewing samples from 101 Hedges Lane, construction samples and color samples. And assuming those two will go off our docket. Under new business, we had 135 Crestview Lane, and they hope to alter and change the house for their changing family. It was adjourned to next month so that the members could do some site visits, which were requested in the discussion. The final item on the agenda, it was 230 Town Line Road. Changes were made from the original approved changes. And that's one that always gets me going because it's kind of like the shed being there in our previous discussion and not having been on the permit. They are looking for the committee to approve what has been built, and that was adjourned to next month. The change is the applicant said minor, and it's 200 square feet per floor. But again, the committee will be investigating that, and assumingly next month decision will be rendered. And that was it. It was a one pager and very quick and easy. That's all I have to say.
Bill, you got anything?
Just on the drainage situation on Daniels Lane, the three of them that have been discussed. The one at Gibson and Daniels seems to be working fine. It is doing its purpose, and I think we accomplished a lot. We did have considerable rain, and there was no problem. As well as down by the Christmas tree farm there. There doesn't seem to be any problem with that drainage area. And the one further down by just past 651 there, just past Potato Road. I don't see any problem whatsoever the way it stands. I think we're making a mountain out of molehill right now. It seems to be.
Which one? The one with
The one with the proposed
$25,000.
drainage on the other side, it seems to be working. Everything seems to be fine.
Where the riprap is,
Yeah,
where you've already approved to have the new design put in. And I've already told the engineers to do it.
Yeah, well, I can always tell them
That's
not
all.
to.
Here's the other issue that was happening there is you, the board, didn't like the big riprap on the side of the road. The other issue was the drop off of 4 feet. There needed to be some safety to prevent a car from going off the side. So the proposal that the village engineer presented to you guys last month and you approved was the extension of the pipe to the north, and then the installation of soil over that pipe to make a gentle slope into the drainage easement on the north side. And then on the south side,
Was to deal with Mrs. Sherman.
he was going to install a drainage, one drainage basin with a pipe, perforated pipe, enclose that in riprap, then put the soil on top of that to act like a French drain. that again would then soften the side of the road and make a gentle slope on the side of the road to eliminate any need for a guardrail or anything alongside the road, and then to also get rid of the ugly riprap that was just
Did he put there?
hanging out.
And
there.
fix her driveway lip.
Well, yes, but that's
That was a
not
separate-
the drainage, but,
Oh.
That was separate. the
right,
drainage.
that was
Okay.
separate.
And I didn't notice whether that was done or not.
I don't know, I don't think.
Nothing's been done there.
No, I'm sure it's not, because the holidays.
Working the way
Yeah.
they
But I,
proposed they were.
and I'm sure it is working the way it's supposed to, but the riprap is still there and it's still exposed.
Yeah.
And there is still a drop off from the side of the road that needs to be addressed.
It needs to be fixed.
Yeah.
Okay. But we want to make sure that Jim is not running around.
Creating.
Inventing problems that need
Oh, that's quite
solutions.
concerned.
Got it.
Okay, Marilyn, you got anything?
Nothing this week.
Nothing this week?
No.
Okay. Mary, you have anything outside of what you've already?
Said my say.
Okay, then, how about a motion to adjourn?
So moved.
Second.
Adjourn for next week at 3 p.m. for the regular session.
Wednesday.
We defer,
We're
what
still on the record,
That's
so
fine,
are you good?
yeah.
Okay.
What we have deferred is this guy who wants a ban on leaf blowers.
Well, that, I didn't, I only sent it to you.
Well, I sent it to everyone.
Yeah. But we did-
There's a guy who wants a total ban on, wants a total, I'm not sure what he wants. He wrote a proposed resolution. Doesn't seem to do what he says he wants to do. The resolution he wrote for us is a full ban on leaf blowers of any kind between, say, May 15th and September 15th.
Get the rakes out.
Yeah, I mean, what he would like is for us to just ban leaf blowers, both electric and gas for all seasons. I don't see how that in this day and age is practical. Some of these houses in the States, there's a, they're carting away 3 truckloads of leaves. There are not enough people in front of the 7-Eleven anymore to get that.
Oh, dear.
But we'll just discuss it next week. I don't know how you feel about it. And then where do you stop? Hedge clippers?
Lawnmowers.
Lawnmowers, next thing you know, everybody
Yes,
has
hedge clippers.
chickens and goats.
Just do.
You also have the problem, which we always come to at some point, of let's pretend we did this. How do we enforce it?
Well, but
That's always a hard one because that one goes on.
we'll have people in here screaming, believe me.
Yeah,
That kind of thing brings people in. The other, sleep blowers, and then you know what? Then we're gonna go to weed whackers and
Agriculture, example.
I'm sure we have to exempt.
Yeah,
that.
okay.
Yeah.
I mean, we can do ban tractors, make just as much noise as a leaf blower. But I am sure if you poll 90% of the village, they'd love a ban on leaf blowers.
Mhm.
unless they have leaves. Maybe we should just cut down all the trees.
No, we have a tree committee, we can't do that.
I think in Southampton Village, they, homeowners are excluded, they can use that kind of stuff. Or at least, some guy was telling me that.
They seem to be all over the map. And
I think East Hampton Village abandoned, didn't they?
well, but we are the village, but it's Sag Harbor, it might make some sense. So houses are really close together, you don't, for most houses, they're not big yards. But
Heard of stereo.
I'm sure, I hate to rake the leaves on my.
Those windows are all-
Neighbor gets tongue.
Right.
We're on the AC.
Yeah.
If you hear on the other side of the house, please not.
It's not every day.
Yes, so this guy wanted to come to the meeting today to do it. I thought we had enough on our plate, so defer to next week and maybe he'll go away, but I don't think so.
Just curiously, what's his name?
Michael Slifka.
Got it.
Is he any relation to Barbara?
Yeah. Yes.
Her nephew.
Your nephew?
Does he live down there?
He lives behind, I was thinking Crestview, but I think he's over on Daniels somewhere.
I think you're right. He's on Daniels, and he came before us. Oh, a year ago, 2 years ago. I'm now lost. We met him.
On the same thing?
No.
Hold on a minute.
You remember.
It was pre-pandemic. I feel like it had something to do with landscaping. Oh, darn it. I'm sorry.
Must be that sun down there, Lisa.
Must be them
Yeah.
palms.
Well, it did rain today, guys.
It was a 19.
It was 70 degrees. Because you're 19, we got colder.
You poor thing.
I want to ask, this is not be happy I'm asking.
We're in session.
We decided on a width for the repaving of Hedges Lane, or is that still open to discussion?
That is still open because they're working on the survey. And I think you were gonna look at the survey and see what you have there before you make that determination. And I don't have that yet.
As I wonder, based on Daniels Lane, if anybody is having second thoughts of about widening Hedges Lane.
I have,
You do.
yeah, I think it was. Daniels Lane is beautiful. It's a great ride a bike or walk. But with the aggravation and you really haven't gained much.
Do you think it's too wide, you're saying?
And what, Hedges?
No, Daniels.
Oh, no, Daniels, I think is fine. I'm glad, I think we did the right thing, but to jump right into Hedges Lane, making it wide again, I think it's just, too inconvenient. People live there and people that travel.
Many more driveways to repave.
Yeah.
And our roads are so straight, I don't see it as being, I don't see it as being a safety issue. Really don't.
No, I think I'd like to see that country road kept.
Well, let's wait.
Yeah.
We've got time on this.
I counted the driveways that have the stone, Belgian block stones, and it was the same number as Daniels Lane, and Daniels Lane had some whoppers with the Renard estate and some of the, width-wise.
Yeah.
So initially, that's very similar. But there are more physical driveways there, but the hard material ones are the same.
Well, let's wait till we see the survey, which will tell
Yeah.
us if it's widened, how much remedial drainage
Yeah,
structures we're gonna need. And-
I think we received a lot of positive feedback on Sagmain and Daniels Lane, and I think,
No feedback on Daniels Lane.
pardon?
I have no feedback on Daniels Lane. Do you, Bill?
Yeah, just from general people.
Say it's nice, you know, it's great. No, I haven't heard a lot of people complaining about it.
Me too. I've got complaints about it from some people who didn't agree with our decision.
I think it should be left alone, I mean, the way it was,
Mhm.
yeah.
And one of the person is, one is an avid biker. She bikes all over the place, but she said, you know, she just didn't agree.
Okay, can I get a motion to adjourn? Sure.
So moved.
Second.
All in favor?
Hi.
I have 2 questions.